So we are very pleased to welcome Camilla Kang, who is a senior research fellow at the Institute for Crime and Justice Policy Research at Birkbeck University of London. She works in moral and political philosophy with research expertise on medical legal conceptualization of mental capacity, the ethics of psychiatry and psychiatric genomics, and the hermeneutics and phenomenology of mental disorder. She's the author of numerous papers, notably this year, of From Best Interests to Better Interests, Values, Unwisdom, and Objectivity in Mental Capacity Law, co-authored and published in Cambridge Law Journal, and also the Hermeneutics of Recovery, Facilitating Dialogue between African and Western Mental Health Framework in Transcultural Psychiatry, co-authored as well. And today she will speak about the phenomenology and ethics of P-Centricity in mental capacity law. So Camilla, if you want to share your screen and start, it's yours.
Great, thank you. Thank you, Sarah and Anne-Marie, for this opportunity and the lovely invitation. So I'm really delighted to be here. So my research really just, I should say that, you know, what I'm presenting is really covering the crux of the interface between philosophy and mental capacity law, which is part of a 3-year project that I am the principal investigator of, and it's the Judging Values and Participation in Mental Capacity Law project that's funded by the Arts and Humanities Research Council. And really this project is looking at the values-based framework and in which judges and legal practitioners make mental capacity assessments and best interest decisions in the legal framework in England and Wales. So this paper is really a kind of normative paper that is part of the broader examination of that project. So just to start out, I want to set up the problem that I want to look at. And in the first instance, I have to give you a little bit of background around the Mental Capacity Act 2005 in England and Wales. And this is really a framework where it is meant to legislate how you determine whether a person can actually make a decision about their life, their welfare, the treatment, their property and affairs. Now, so persons who are not found to lack capacity are free to make one or more of their own decisions regarding their care, treatment, and financial affairs. So those are the people who are found to not lack capacity. But there's a diagnostic threshold which alerts as decision makers whether they actually need to probe whether one's capacity needs to be assessed. Now, this ideal of making one's own decisions obviously reflects this liberal commitment to subjective freedom and self-determination. So if you have capacity, effectively, you are free to make your own decision. And it specifically states in the statute, you're free to make this decision no matter how unwise it may be, that the unwisdom of a decision is not coextensive with a lack of capacity. Now, if you are found to lack capacity, you're persons who lack capacity, who are short term as P, which is not an ideal. It's a very clumsy abbreviation of this, but persons who lack capacity are subject to a best interest decision. And so a best interest decision is effectively an objective test where you decide and act on behalf of a person. And there are certain criteria that this best interest decision must consider. So you have to consider whether this individual will regain capacity. There has to be the involvement and participation of the person who lacks capacity as much as possible. And then there's also the decision maker has to take into consideration a person's past and present wishes and feelings, their beliefs and values, and other factors that would likely influence the person's decision if they had capacity. So really, effectively, if you think about the normative imperatives that guide those who have capacity and our treatment of those who have capacity and those who do not have capacity, you can see that it seems to be these two normative imperatives of autonomy versus welfare that orient our obligations to individuals under the MCA. And it effectively demarcates the treatment that is owed to these persons based on this capacity divide. But what is also interesting is about the best interest standard itself. And then you think about the various considerations of best interest. It suggests that we need to consider a person's past and present wishes and feelings. So there's an impulse towards this normative imperative of autonomy, but it's framed with an objective test, which is around welfare. So there's a potential conflict within the best interest standard itself. Now, this conflict is not in and of itself an issue, but it has created some tensions in the way that best interests have been assessed. Now, the best interest, this conflict, this potential tension in the normative imperatives and best interest decision making is, in theory, has been resolved by the Supreme Court decision, Aintree University Hospital NHS Foundation Trust v. James. And you don't need to know all the details of this case, but it really surrounded making a best interest decision in the face of clinical best interests, in a sense that the clinical team had a different account of what was in the best interest of an individual. And it really revolved around medical futility and a definition of futility. But what was important about the Supreme Court decision was that it was thought to settle these kind of long-standing problems associated with these competing imperatives in the best interest standard. So in the judgment, Lady Hale, she places significant weight on the subjective values and wishes and feelings of P, and this is framed within a holistic consideration of best interest. And so this notion that there is weight on the subjective values and wishes and feelings of P is important, because it is important even in the case where the escalation of treatment is not likely to lead to recovery or an improved quality of life. So in this judgment, it is perceived and interpreted as that the principle of autonomy somehow guides both sides of our treatment of individuals, regardless of which side you fall on the capacity divide. Now, in practice, the approach that is advocated in Aintree has proved still problematic. So there is a sense in which that there is a commitment to subjective freedom, but judicial interpretations post Aintree have really tried to push against this and limit this liberal commitment to subjective freedom in favor of more objective considerations. So there's an emphasis on this objectivity. Now, why it's important to kind of probe this is because cases that are involving significant communication barriers, where an individual has lifelong incapacity due to profound impairment, it has meant that there has been very inconsistent interpretations by amongst judges in their judgments about how best one discharges our legal and ethical obligations to P in the best interest standard. So there are real two issues in mental capacity law that this has created this context. First of all, it's a problem of normative framing, because in the context of best interest decision making, there is an inherent moral complexity, uncertainty in that kind of decision making, and this moral complexity is somehow treated as reducible to a conflict between these values of autonomy and paternalism. And we see this time and time again in discussions around mental capacity law, that we somehow, when we try to think about the values that are most prominent and important, they are seen to be the values of autonomy and paternalism. Now, this gives the impression of a kind of normative instability intrinsic to the principles of the MCA. And this, as we see, will have profound impacts on persons whether or not they have capacity. So if you have capacity, then you are seen to actually be free to make your own decisions, regardless of how unwise they might be. But yet, if you are found to lack capacity, then you might be subject to a welfarist framework, right? Now, from the direction of capacity, our obligations to persons with decision-making capacity then appear just to protecting this sphere of negative freedom. And the implication, which has a real profound practical implication, is of how there is a kind of neglect of providing positive institutional support that might well be required. What is really particularly striking about this is that in some of our empirical interviews as part of the project, where a legal practitioner stated how, this person was found to have capacity, but there was all sorts of things that he was going through in his mind, thinking, well, if we find this person to lack capacity and we subject them to a best interest framework, they would have all these positive institutional supports at their disposal, in terms of funding, in terms of access. And that is really, really quite remarkable. Now, from the direction of best interest, if you will fall under the best interest rubric, the obligations to respect or consider the view of a person with lifelong incapacity or communication barriers, this obligation appears dispensable, and it's premised on this kind of discretionary judgment of the best interest decision maker. So this normative framing really has created some practical implications. But this has also then led to a reductive interpretation of P-centricity. Now, so practitioners and judges in their interpretation of the MCA often talk about P-centricity as that we put P at the center of our deliberations. Now, this P-centric ethos, what this meant based on this reductive normative framing, is that it has become overly subjectivist, where there is unclear the import of this ethos of P-centricity, as also a way of negotiating the moral uncertainty that characterizes the essence of best interest decision making. And and one can say that best interest decision making is intrinsically has this moral complexity and uncertainty. So P-centricity in the best interest standard and this empowerment ethos within the MCA more generally then is thought to just entail this kind of liberal commitment to subjective freedom, this kind of the first no of that expressed no of the individual is treated as paramount, the preferences of the individual are treated as paramount. Now, these two issues combined have led to this impoverished understanding of P-centricity as a common normative grounding for obligations to all individuals, regardless of where they sit on the capacity divide. And that's the essence of my argument and diagnosis of this issue. So my argument is that I want to critically examine this concept of P-centricity as a means of enriching and deepening the normative orientation towards persons with best interest decision making. And I think that this will have also implications for persons who are found not to lack capacity, so who have capacity to make their own decisions. So what I want to do in this presentation is explore the common normative grounding across the capacity divide to help explore this P-centric ethos in mental capacity law and show how it's not reducible to this uncritical accession to P's subjective wishes. And so just pushing against that really overly subjective interpretation of P-centricity. And what this involves is this phenomenological and ethical stance of moral considerability and recognition respect, which I would argue helps us negotiate this moral complexity that is the essence of best interest standard and mental capacity law more generally. So the structure of my argument is I will firstly look at how there's some judicial uncertainty in the case law as this normative vector of P-centricity, what it entails. So actually looking at the phenomena of judicial interpretations, it's not clear at all what P-centricity means. In the first instance, there's clear precedent for legal constraints to subjective autonomy. And then I want to look at the kind of the meat of the argument, which is the phenomenology of P-centricity as moral considerability and recognition respect. And then finally look at the practical implications in the practices of mental capacity law on either side of the capacity divide and what this means. So what is this judicial uncertainty that we can see in the best interest standard. So obviously there has been an attempt to articulate P-centric obligations that somehow cut across the boundary between capacity and incapacity. And it really turns on what does it mean to empower P within the confines of the MCA, and particularly in the best interest standard. And this empowerment ethos has really, as I mentioned, has meant a kind of tension in the way that best interests have been interpreted. But we need to think about that this tension in the way that it is actually productive. It's actually reflective of the moral complexity that is intrinsic to both the phenomena, as in the cases, and the kind of subject matter of the cases. So this involves people's lives and the complex messiness of these decisions. The phenomena is messy, as well as the substantive deliberative mechanisms that are necessarily involved in deciding in light of such complex phenomena. So the deliberative mechanisms are not overly simple, they're not procedural. We cannot actually appeal to some kind of procedural rational deliberation to make these types of decisions. They involve appealing to value judgments. So effectively, discretion in and of itself is not a problem. There's a lot of legal discussion around discretion and the role of judicial discretion, but in fact, I would argue that discretion is part and parcel of this best interest standard. But what we really need is a clarity about the normative vector in this discretion. So P-centricity in the context of judicial interpretation is often seen and appealed to as a normative vector. Yet this concept, as I have suggested, it's currently unnuanced. It does not actually help anchor and ground discretionary best interest judgments in a transparent and justifiable manner. Now, we can see that, in fact, even in Aintree, this Supreme Court judgment that has seemed to be expressing the importance of subjective values, it actually articulates a constraint to autonomy. And in this judgment, Lady Hale says this: the purpose of the best interest test is to consider matters from the patient's point of view. So it's a kind of substituted judgment perspective. That is not to say that his wishes must prevail any more than those of a fully capable patient must prevail. We cannot always have what we want, and nor will it always be possible to ascertain what an incapable patient's wishes are. Even if it is possible to determine what his views were in the past, they might well have changed in the light of the stresses and strains of his current predicament. Insofar as it is possible to ascertain the patient's wishes and feelings, his beliefs and values, or the things which were important to him, it is those which should be taken into account because they are a component in making the choice which is right for him as an individual human being. So typically, interpretations have focused on the latter half of this paragraph about the importance of the person's perspective and their wishes and feelings. But what is also actually not really taken into account is the first three sentences about how there are certain constraints to autonomy. Now, in this context, when there is a suggestion that there is qualification of negative liberty, that even persons who have capacity do not have unconstrained liberty to have their wishes prevail. It's always framed within certain constraints. And I know that this is not the deeper philosophical point that Lady Hale is making, but I do think about Charles Taylor's argument about how in his criticism of negative liberty is precisely this point, that it is a mistake to somehow presume that this unconstrained liberty is not framed within broader constraints. But within the Aintree judgment, in this legal context, what they are thinking about is the constraints about what is practicable, medically possible, and clinically appropriate. So, but it is important nonetheless that there is this qualification of negative liberty. And in fact, there is an earlier Court of Appeal judgment in the Burke judgment where they also have certain reservations towards negative liberty, where they talk about this judgment refers to a duty elsewhere that remains rooted in the common law, whether in terms of medical practitioners and what they're obligated to provide in terms of life-sustaining treatment for a person. And so, but when they're talking about this duty elsewhere, they're talking about that the duty to prolong a patient's life is not absolute, and they talk about in the original judgment that that was a part of the appeal. There was an emphasis on autonomy, and the Court of Appeal effectively said, well, this emphasizing the value of autonomy in this context actually disregards that there are obligations and duties that also might precede and limit our autonomy. So there is important legal precedent for limiting the right of self-determination, regardless of if a person is found not to lack capacity. So what this indicates is, even in judicial interpretation, that considerations that are owed to an individual perspective might also be separable for our strict obligation to somehow comply to them or instantiate them. So even where subjective wishes might be enacted, and a P-centric ethos might well be absent. And that's a different inflection to what I would argue the legal precedent is suggesting here. So I don't want to, this was simply to say that there are kernels in the law that indicate that that there are certain constraints to subjective autonomy. And so even just this overriding emphasis on autonomy in the best interest standard is problematic from a legal perspective. But from an ethical perspective, I think that we can actually, I've suggested that there's a kind of reductiveness is understood as acceding to subjective wishes and feelings, and to really ground and enrich a notion of P-centricity that is far more complex. I want to look at the phenomenology of moral considerability and recognition respect, and I want to appeal to these two normative concepts as a kind of providing a common experiential and normative grounding that can somehow inform our obligations that are owed to persons, whether or not they are found to lack capacity under the law. And it is importantly, in my theorization of it, it's prior and separable to the principles of autonomy and welfare. It's not kind of coextensive with either value. And it's prior and separable in the sense that it is a primary experience and obligation at the core of each interaction with persons who might be the subject of mental capacity proceedings. And it is prior in the sense that it is a condition on which obligations of autonomy and welfare ought to be discharged towards such persons. And there's no prima facie presumption that deliberations and outcomes that either respect autonomy or promote welfare is coextensive with this ethic, because in fact either outcome could in fact show an absence of P-centricity in this account. So what is moral considerability? And here I've adopted Thomas Birch's definition, and he writes, to give moral consideration to X is to consider X, to attend to look at, to think about, where appropriate, to sympathize or empathize with X, etc., with the goal of discovering what, if any, direct ethical obligations one has to X. So what is notable about Birch's definition is its expansiveness. It is very open-ended, and this expansiveness is I think theoretically significant and normatively significant, particularly because of when we think about moral considerability and criterial approaches to this question of considerability, which is based on drawing a boundary around that circle of moral considerability, and it's premised on candidate features such as rationality or personhood, moral capability, and I think that these are the focus on these candidate features is particularly problematic when we're talking about those with impaired cognitive abilities. And criterial approaches effectively rest on a contentious conflation between questions of considerability, which is what we ought to consider as ethically appropriate to attend to, and questions of moral significance, that is, what weight we accord to competing claims. And so there's a presumption that somehow moral considerability is reducible to that question of weight, of moral significance. And so what I would suggest is that we need to reclaim this primary sense of considerability as this attentive, reflective contemplation of something, where certain things matter intrinsically and warrant our ethical attention without necessarily predetermining how we relate to it, what weight we accord it, and how we value it. So moral considerability is effectively this normative orientation that is constituted by a kind of openness, attunement, and provision of space for which the intrinsic value of an entity might be revealed. So it's just actually providing space for that value and that revelation of value. And so the reasons behind moral consideration are effectively left open. Allows for different ways in which our practices and relations might be ethically responsive. It doesn't predetermine what is ethically responsive. But there is nonetheless this core deontic experience where there's a sense in which one must and is called upon to do something that is in a sense of giving attention and responding appropriately and relating in a responsible way to the object, to the person or the entity being considered. Now, what moral considerability does, it provides a space, it articulates this open space, but it doesn't actually clarify what the content of this deontic urge is. And we need to think about how we might pin down the positive valuing of persons and mental capacity law. So we need to think about, well, what is the core experience of showing due regard? And due regard is one of the phrase that one of the judges uses in a key judgment. It's like, how do you show due regard to individuals, whether or not they're found to have or lack capacity? And how does this ground a consistent normative ethos, whether or not their values and wishes are determinative in best interest decision making? So we need to have some further content to clarify and help us answer those two further questions. And for this, I want to appeal to the phenomenology of recognition respect. And in this definition of recognition respect, I've adapted Stephen Darwell's definition, and my definition is acknowledging, taking seriously and weighing appropriately the fact that they are persons with a separate consciousness and being. Now, in Darwell's definition, he talks about deliberations and persons, and I have tried to avoid his particular definition precisely because there is, I think it rests on a criterial definition. What I'm trying to capture is something far more existential, but the experience of coming into contact with a separate consciousness. And this is a kind of pre-reflective phenomenology of coming into contact with other persons. And this sparks a special kind of experiential awareness and other directed attitude that is both empirically and normative significant. And there are two sides of this phenomenology, this pre-reflective phenomenology, and they're both in tension with one another. So on one hand, when we, if you look at the phenomenological tradition, there's a kind of obvious and unreflected everyday sense of a shared world, that we are part of a shared world, that we have this common perceptual mode of being and our relations with our environment and with each other, that we share this world and we don't actually even need to reflect on it. But there is also a second side to this phenomenology where you come into contact with another consciousness and it is actually disruptive to this presupposed everyday commonality. There's a kind of awareness of an alternative world model and intentional directedness. And where it becomes particularly acute is when we encounter divergences in perceptual experience, where the form of the experience is radically divergent, and we can see this in contexts of autism, in mental disorder, in real divergent forms of actually experiencing the world. So recognition respect, really, if we're thinking about that phenomenology of coming into contact with separate consciousness, now to minimize the divergence or look at the differences only at a surface level, to look at the content, the experiential content, but not disregard the divergent experiential form, would I argue it would fail to reflect this phenomenological stance and ethical orientation that is required to express this stance of recognition respect. Now, for recognition respect, what we need are two aspects. We need radical empathy, and we also need the descriptive and normative experience of inviolability. So it's these two facets, it's an other directed attitude insofar as it allows space for the distinctiveness in content as well as structure in the experiences of the world as experienced by another person. But it's also self-affecting insofar as there's an openness to experiential difference, and it impacts one's own consciousness and alters the ethical response to such difference. So let me look at radical empathy first. And this is, I draw from Matthew Ratcliffe's account, where he makes a distinction between mundane and radical empathy. Now, mundane empathy, it involves this habitual presumption of a shared world, that we are both in this shared world, and that immersion effectively enables one to make sense and understand the experiences of another. But radical empathy, in fact, involves this suspension of this ordinary presumption in order to actually make better sense of the thoroughgoing variations in experience. And this is particularly relevant and important in those experiences where the form of experience is altogether different, and we cannot actually understand the experience because it has this divergent form. And a good example of this is Naoki Higashida's account of what it means and how he lives as a nonverbal person with autism. And he writes two beautiful books about this. In The Reason I Jump and Fall Down 7 Times and Get Up 8. And he gives he gives an account of various questions. Why do you run off? Why do you do this? Why do you do that? And it's beautiful in as far as he talks about how the way that we have to suspend this ordinary presumption in order to make sense of his experience. But there's experience that, in addition to this radical empathy, we need this experience of inviolability, and it involves a recognition that one is encountering the intentional directedness of another, and this encounter means that we cannot fully grasp or control or know that intentional directedness, and it's self-affecting in an empirical sense, in a sense that it modifies our consciousness of what is possible, makes one aware of our limitations, and it induces a sort of humility that the contents of another conscious mind is not fully knowable, even with all our tools at our disposal. And it is also normative in a sense that it is an other directed experience, and that is action guiding, and it's action guiding in a negative sense that requires what Kriegel talks about in terms of extra care, pulling back so that one refrains from correcting others about their intentional states. Now, what this does is it leaves some space for the understanding of an engagement of an entirely different way of experiencing the world, such the way that the experiences of another are no longer isolating and alien, but they somehow enhance our concept of what is possible. And Naoki also provides a lovely example of this. He talks about how he comes to enjoy picture books in Fall Down 7 Times, Get Up 8. He was saying how I just could not understand what the point of picture books were, and his mum would read him picture books and he would just run off, but his mother noticed that he would look through family albums, and he would just constantly, he just enjoyed those. And so what effectively she did is she used the family album and just put little narratives under the family album to actually try to engage with his experience of the world. And that's actually how he came to engage and enjoy picture books. So that's a beautiful example of that, how his mum came to just experience and engage with a completely different way of experiencing the world. Now, what are the practical implications of what I have stated here? So I think that the fact that there's this ethical phenomenology of moral considerability and recognition respect is action guiding, mainly in a negative sense. It is important, and it actually helps explain why best interest and our definition of best interest is so elusive. If you look at a lot of the practice guidelines, judgments, best interest is defined always negatively about, well, what it isn't. And this is really interesting about, I think that the ethical phenomenology tracks this in many ways. But as the basis of a P-centric ethos, more considerability and recognition, respect, helps express what it means to provide space for P's mode of experiencing and engaging with the world, and also highlights actually the substantive depth and the ethical justification behind requirements in the MCA to fully consider P's perspective about their past, present wishes and feelings, their values, and that is significant. Why is that significant? And I think that this P-centric ethos that is grounded as in what I have described helps give it that weight. But it is also important because it can identify where a P-centric ethos is absent in practice, and this could be a case whether P's subjective wishes are acceded to or not. And we see this especially in cases involving persons with lifelong incapacity and communication barriers. And I want to just highlight one particular case. This was a recent case that came to the Court of Protection. And this was one where Edie was a 35-year-old woman. She was a quadriplegic with cerebral palsy. She had severe learning difficulties. She lacked verbal communication, and she communicated primarily through facial expressions. Now, this case really revolved around the trust that did not actually want to escalate her treatment. Her deteriorating respiratory condition had meant that she was increasingly dependent on clinical intervention. So the trust wanted a declaration that would say that it was Edie's best interest to avoid future invasive medical treatment in light of what they argued would lead to a worsening quality of life. Now, Edie's mother opposed the declaration, saying that it should be Edie's decision as to whether or not to give up fighting or to give up the battle. And her mother said this is not, she wasn't doing this at the moment, she's fighting, and that Edie's life is worth living. Now, what is really remarkable is Mr. Justice Moore, and in the judgment he states, in somebody with Edie's conditions, I consider CPR and other resuscitation measures quite intolerable and burdensome. And legal counsel that was representing Edie and her mother, in fact said, well, you haven't actually considered Edie's perspective. You haven't actually fulfilled the obligation to consider under Section 4, Edie's present and past wishes and feelings. But this is what he said in response. He acknowledged that he had disregarded Section 4, and he said that Edie would recognize that the treatment she is getting on the respiratory ward is excellent treatment, and that for her to have to go through the additional invasive treatments of the ICU and CPR would not be in her best interest, because it would be futile in the long term, and it would be likely to cause her pain and suffering and not achieve any advantage. And what I would argue is that this judgment reflects a failure in both phenomenological stance and ethical orientation in important ways. So in the first instance, we cannot say that a P-centric ethos could actually justify Mr. Justice Moore's reliance on this hypothetical, idealized, capacitous person about what Edie, if she had capacity, would want, to the neglect of the actual incapacitated person. And there was a presumption that was throughout the judgment that Edie cannot use language, and that meant that she cannot engage her experiences at a cognitive level, and therefore her experiences must lack meaning and value for her. And this is really problematic. In fact, one of the examples was how counsel had emphasized how, and the mother of Edie's mother had stressed about how they went to literary festivals and they enjoyed these kinds of activities together. And there was a sense in which, well, why are you bringing this information? She cannot use language, she cannot speak. So, and you're going to literary festivals, she can't understand, so it has no value to her. And what is actually, I would argue, is that there, in this case, the presumption of a shared world must be suspended in order to express the radical empathy that I've articulated, make space for a fundamentally divergent way of experiencing and the possibilities that they represent. So Edie might not actually be able to understand the poetry reading, but she actually might still experience value and meaning from that shared experience with her mother. And importantly, Edie's separate consciousness and her intentional directness and world model exists regardless of her nonverbal nature, with the distinct possibility that her ways of experiencing the world can affect others. I mean, and her mother was really eloquent in describing how Edie's separate consciousness affected her and changed her, and it can alter shared meanings in profound ways. And what was interesting is to contrast this at a kind of another case, which you don't have to go into too many details, but Mr. Justice Mostyn said that the workings of a grossly incapacitated mind is a largely undiscovered country. And barring the kind of clumsy language, it is incredibly, I think it articulates the essence of it, about not presupposing the intentional states and somehow presuming we can determine the content of those mental states. So what are the practical implications on the side of incapacity, on the best interest, the side of best interest? So that a person might be unable to communicate clearly or have experienced lifelong incapacity has to induce a certain humility on the part of the best interest decision maker. Not being able to clearly elicit and know what P wishes means that those who are in the place of the best interest decision maker have an even greater moral and ethical responsibility to resist this impulse to project about P's subjective state. And the communication barriers make this orientation all the more critical, which reinforces the ethical imperative behind the legal obligation to consider a person's subjective perspective. And this, the other side of pulling back with care, that kind of negative, that experience of the deontic urge in a negative sense, is accompanied by this more enriched positive duty to be open to alternative experiences in considering P's wishes and feelings, making it an essential rather than a dispensable part of best interest decision making. But it's also, importantly, my discussion has implications on the side of capacity, and I know that I haven't discussed this, but I want to just touch on it briefly. So those who are found to not lack capacity, who have capacity, typically fall out of this discussion, that there's a presumption of capacity, autonomy has won out, that's all there is to be said. But this ethical moral considerability and recognition respect also challenges this simplistic equivalency that is made between P-centricity and acceding to subjective wishes. What this has meant when we talk about the implications about, the persons with capacity, it can imply leaving individuals to it. And there was a 2014 post-legislative scrutiny report by the House of Lords, and there was expert evidence that talked about the unintended consequences to this misguided equivalency, where it left vulnerable adults to harmful situations, sometimes death, as a result of individuals disengaging from services or insufficient scrutiny of those decisions on the basis of that presumption of capacity by professionals on the ground. And very briefly, and I can talk about this in a little bit more detail if you are interested, but there is a court's use of inherent jurisdiction, which is precisely to deal with these situations. And I think that there is it's warranted, and it can be ethically warranted through this lens of moral considerability and recognition respect. So just to conclude, ultimately, my argument is that P-centricity requires this phenomenological stance and ethical orientation that is receptive to profound experiential difference in content as well as form, and through the lens of moral considerability and recognition respect, it is not just a supplementary obligation to consider a person's wishes and feelings and values, particularly in the context of lifelong incapacity. And what this P-centricity ought to do is inspires this radical empathy and humility, which precludes making projections about how individuals experience and the extent to which individuals have these subjective values and feelings, as well as their constitutive content. And it also is responsive to that moral complexity, about that uncertainty, and the role of values, and in terms of how we make a best interest decision in mental capacity law, that we need to engage with a more enriched array of values as opposed to just autonomy and welfare. And so P-centeredness is not just associated and coextensive with the value of autonomy or welfare, but it provides a kind of common ethical grounding in our treatment of persons, whether or not they lack capacity and whether or not their subjective wishes have been acceded to. Thank you very much, and I will stop sharing. I look forward to your questions.